going on? How's everyone doing?
Everybody else who's cool with Colin.
Chunky! I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. I've got a good one. It's a weird one. It's actually weird and interesting at the same time. This claims that he didn't fail a drug test. He put water in the cup because he was being harassed by the person giving him the drug test. And then he claims corruption because it was water, and there's no way he could have failed a drug test if it was water. Now, there's a lot of things wrong with this, and we're gonna have to watch what happens. So, yeah. Oh, also, this is all based on him getting a DUI. So, he has a DUI. He's on probation, and yeah, and he put water in a cup. So he shouldn't be charged with the DUI because he put water in a cup. Yeah, again, doesn't make sense. So let's just watch it. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump backflips. Let's go.
This is State versus Josiah Nixon. Mr. Nixon, you are here today on, I believe there are two things. One of them is the attorney status that we were checking on. Have you hired a lawyer?
I didn't get a chance to, Your Honor. I figured haven't had a chance to even. I talked to one over in Paris, and I've had a chance to get any money up for it, so I've got a little bit at the bank, but I haven't had a chance.
Well, you're in custody at the present time. You would be entitled to have counsel appointed for you. If you're not able to hire your own, do you wish to have a lawyer appointed?
I suppose for the time being, that'd be the only option I have. I don't have.
Is Mr. Clemens still here, or is he already left for the day? All right, I'm going to appoint the public defender to represent you.
I think they have conflict. Yeah, I was gonna say, yeah. I think they have a conflict. I think there's another attorney that has conflict.
What about Crystal Wilkerson? You ever had any contact with Miss Crystal Wilkerson? All right, I'm going to appoint Miss Crystal Wilkerson to represent him. The only other thing that was on the docket today was the state has filed a motion to revoke bond. He is in custody at the present time. You want to tell me why he's in custody right now?
I can, Your Honor. He was on bond for something, on bond for this circuit court DUI here, which is what the motion is filed on. And he was on bond for some charges from February, and then on April 3rd, he got arrested for
The cop says
5 more charges in Sessions. So the state will be asking Sessions to also revoke his bond there. And I've got the Sessions files with me, Your Honor, would like to see the original affidavits.
All right, do you understand, Mr. Nixon, what the state is asking that your bond in this case be revoked based upon the fact that you have been while on bond for this charge?
I would request a fast and speedy trial and subpoena these court records for the telephone records that I was arrested for on this charges here that I'm here for now, because phone call, he's saying he was too lazy to listen to a phone call on the messaging at the jail is why I'm here now, why I got arrested, why they were stalking out my house, you know what I mean? Like, so I would request a subpoena for those phone records and a fast and speedy trial. That'd be excellent for me. That'd be excellent because there's no evidence
I can give you
whatsoever for this DUI, and that would be actually get that knocked out of the way. And
well, I can set you a trial date on the DUI case, which is the only thing that I have here
okay.
before me.
I mean, part of the reason why they're asking for this to be for it to be you know what I'm saying, for them to issue this no bond hold for hearing would be for the reasoning in the other case. So I mean, I can see ordering that too. I mean, I don't see why you wouldn't be able to do this, but that way it's already there for the next time when it comes up to court. It'll be there, and I can go ahead and play that for the honor that way. You know, so we don't have to sit and wait and parlay and wait another 3 to 6 months for the jail to come up with those records. Does that make sense?
No, I have no idea what he just said. And this is the second time I've listened to this. I have no idea what he was trying to say. And I'm not even trying to make fun of him. I don't know. He wants to subpoena all the records so they don't have to sit there and parlay. He's not waiving Speedy because he doesn't want to sit for 3 to 6 months. That part makes sense. Somebody help me make sense of this, please. Comments, please help.
Well, you're wanting to have a lawyer represent you on the DUI charge.
Yeah, yes, sir, but I don't have one representing me yet, so, I mean, you know what I mean, there's no one here to represent me yet, I just go ahead and, you see what I'm saying, like, I'm well versed in the law to a point, you know what I mean, I'm not well versed in the law, but I'm a little bit versed in the law, I spent 4 years.
So the question I'm asking you is that you're asking for a speedy trial, and I've just appointed you an attorney. Do you not want to have your lawyer at least give you some advice about this situation?
I mean, there's no sense in it. There's no evidence in the trial. There's no evidence in this case. The evidence is a urine test given by a lab tech who when he wouldn't quit bothering me, I poured water in the cup. I didn't even piss in the cup. And they're saying this is their evidence. There's no blood work. There's no, so I mean, like, you know what I'm saying? There's no blood work. There's no TBI work. There's no nothing there. So, I mean, where is this DUI coming from? That makes a difficult decision. If there is evidence, I would love to see it because there isn't any. That's all I have. Whoever gave me any type of blood work was Paris, and that's not here. I mean, that's their evidence is a urine test that was given by a lab tech. Who when he wouldn't quit bothering about it because I take a urine pill, so I pissed everything out of me in the morning. I mean, like, you see what I'm saying though? Where's the evidence? There was no reason for these charges to be getting charged. They come and kicked open my door. 3 days
How long will it take you to get your witnesses?
This is actually general, sorry.
Both of the DUIs are like
Your
this.
Honor, this is General Woodall's case.
Yeah, he's
One of the deputies is, I mean, that should be easy as far as, I think we would need somebody from the hospital. I don't know how long that would take. But I can add.
Where's TBI's reports? I believe DUI has to be backed by TBI and PBI test. There isn't one. I believe it needs to be thrown out at this point right now is what I believe really, because I'm filing a lawsuit for this. Like it's constant harassment by General Woodall, not you, man. By General Woodall.
Right, on your bond motion, you said you had copies of the new charges.
And we have the officer here on the new DUI, Your Honor, for testimony. But
Same
we
situation.
also.
Mr. Nixon, have a seat over there at the table.
Also, I mean, Your Honor, at this point, we have the officer here to testify that he arrested him on the DUI, but I have the court files with the original copies of the charges. Now, I don't have any officers here on the ones that he was just arrested for. But I'd ask the court to take notice of the new
Well,
charges.
number one, the motion is based upon the fact that as the statute provides, someone who is on bond, who is arrested, not convicted, but arrested on new charges, can have their bond revoked because of that fact. So that is upon which you're relying, is that correct?
Yes, Your Honor.
And you have copies of the new charges against Mr. Nixon?
I have the original charges here. I'm passing up right now. They are the court files. And we will be filing to revoke his bond in Sessions Court as well, based on the arrest from last week.
Right. I'm going to hand those back to the clerk. Your motion recites that he was placed on, he was arrested for simple possession on February the 21st of this year. He was arrested for simple possession of methamphetamine, Class A, and you have submitted a copy of that arrest warrant. He was also on that same day arrested for simple possession of casual exchange in Stewart County. That also was attached. You've also alleged that he was arrested for driving under the influence in Stewart County, Tennessee on February the 21st. And he was also on that date arrested for possession of unlawfully drugged paraphernalia. And he was arrested for violation of conditional bond, Class A misdemeanor. And he was arrested for reckless driving on February 21st, failure to exercise due care, and no driver's license, and a violation of seatbelt law. And that in this particular case, he was on bond for driving under the influence, and that as a result of these additional charges, you're asking that his bond be revoked.
Yes,
Right. Under 40-11-141 of the Tennessee Code, subsection B, it states as follows. If a defendant is released upon personal recognizance or an unsecured personal appearance bond or other bond approved by the court, the defendant violates a condition of release, is charged with an offense committed during the defendant's release, or engages in conduct which results in the obstruction of an orderly or expeditious progress of the trial or other proceedings, then the court may revoke and terminate the defendant's bond in order the defendant held without bail pending trial or without release during trial. So this, the state is relying upon the fact that an offense was committed, several offenses were committed during the defendant's release. So based upon Tennessee Code 11-141, the state's motion to revoke bond is granted. I have appointed an attorney for Mr. Nixon, and we are looking for a speedy trial date. You know when the first available trial would be next month?
That is General Woodall's. You know what our trials, I think I have the 15th and 16th. What all does, General Woodall have?
I don't right here.
Let me see. Look at my calendar. I mean, we can set them just for the 15th or 16th for trial. That's a trial day.
15th and 16th of May.
Or to be postponed, if it's gonna postpone, it needs to be thrown out, because this is bullshit. I'm not gonna sit here and do with it over.
Watch your mouth. You know, I understand what you're
Sorry,
saying.
Your Honor. Sorry, but
You just need to listen to what we're doing. I've given you a lawyer. We're going to give you a trial date as speedy trial means that you're entitled to have one as quickly as we can arrange it. If it next month, it's pretty quick.
This goes on and on and on. They push it out, Your Honor. I'm not going to tell, I'm saying for, you know what I mean? I will. I'll sit in jail as long as you tell me I have to sit in jail. But when it gets to the point where that they keep pushing it out because they don't have any evidence, and which is what Stewart County likes to do for months and months and years and years and years, this case should have been taken care of over a year ago at this point.
Yeah, all right. I'm gonna throw a flag on that one. Okay, so he doesn't have an attorney, and he has said on the record that he's gonna hire an attorney. So I'm guessing he was charged with adjournments of the cases. Yeah, so it's not pushed out because the prosecution is looking for evidence. That's not how that works. They might be, fine tuning their evidence while they're waiting for trial, but the charging documents with the police reports, that's what they go by on DUIs. I mean, we're not talking about some super secret scheme that they've been building against you for years. It's DUI, and you put water in a cup when you were asked for for the piss test. Yeah, there's a reason you're in jail, man. And yeah, just take the attorney. He'll figure it out for you. All right. Told you this was a weird and interesting one. I'm gonna let the rest of it play out. You guys have a great rest of your day. Please hit that like button if you haven't. Until next time, bye.
We've got the 13th, 14th, 15th, and 16th available as holidays.
For May,
Yes, sir.
let's just set it for May 13th, first available day.
Thank you, Judge.
All
I
right,
really appreciate it. You've always been fair and honest.
your trial date is May 13th, and your lawyer is Crystal Wilkerson. She'll be notified of that, and we'll go from there.
All right, thank you, Judge.
Thank you.